Good morning, everyone. The time is 9 a.m. My name is Christian Waugh, and I hereby call the October Code Compliance hearing to order. We have an agenda for these hearings. The first item is the call to order. The second item is the pledge to the flag. So I would ask that you join me in standing for the pledge to the flag. I pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you.
Good morning. If any person decides to appeal any decision made by the Code Compliance Special Master with respect to any matter considered at this public hearing, he or she will need to ensure that a verbatim record of the proceedings is made, which record shall include the testimony and evidence upon which the appeal is to be based.
So the next item on the agenda is to approve the minutes from the September 2022 hearing. And looking through the minutes, I don't have any revisions or objections. Does anyone else have any proposed revisions or objections to the minutes as they've been currently formulated? Hearing none, I will approve the minutes.
Staff update abated cases and continued cases is posted out front.
Okay. I'm not sure, Mr. Tron, if the mic is on or if, just FYI. All right, so again, good morning, everyone. My name is Christian Waugh, and I'm a licensed Florida attorney acting as what is called a special master. That's a fancy title created by the law, but what it means is that Citrus County has hired me to preside over your hearing today. When your case is called, please come forward and you'll be placed under oath. If you are appearing at a hearing like this for the first time, I'll state the alleged violation and allow the county to first present its case. After the county present its case, I will give you an opportunity to present your case regarding the violation, which may include evidence if you wish. During this process, the county attorney's office or myself may have questions of the parties, witnesses, or staff. I'll ask if there are any members of the public who wish to speak, and if there are, such members of the public will have one opportunity to speak per case. Such right to speak is not unlimited, and public comment should be focused on the case and made as briefly as possible. This is not the appropriate forum for personal attacks. In most instances, if you are found guilty of a violation, the law requires that you be given time to comply before a fine begins. You must abate the violation by that date, that is, fix the violation, or the fine will accrue for each day that you remain in violation. The law then allows Citrus County to impose that fine as a lien on your property, and the county may foreclose on that lien or seek money judgment against you after the lien has been recorded for 3 months. It's important you know this because I may not give another date to appear before me, and therefore you likely will not have another opportunity to plead your case or to explain why you didn't comply with the county code. The county will continue maintaining its liens against your property until you notify the county of your compliance. In all cases in which I find someone guilty of a violation, I'll impose the costs required by county law. If you abate or fix the violation in the time allotted, that cost will remain minimal. If you do not timely fix the violation, you'll be responsible for additional costs, as well as the cost of the lien that's imposed. If I find you guilty of a violation and allow for a continuance of your case, you'll be required to return on a certain date. In the time between hearings, I'll require that you comply with the county and its code in order to consider the violation resolved. If your violation is not resolved by that next date, I may impose a fine for each day of the violation from today's date forward. Your failure to return on the date may be deemed evidence of your failure to cooperate with the county. Are there appeals of orders to Okay.
Yes.
If you are here today for an appeal of an order to demolish, repair, secure, and or vacate, then things are a little bit different. It is your burden to establish why the county is wrong. My function is to determine whether the county has met the elements under the law that require you to demolish, repair, secure, and or vacate a property. I do not have the authority to grant you more time. I do not have the authority to require the county to allow you to repair something that meets the criteria for demolition. That is solely within the county's discretion. For everyone here today, you do have the right to appeal any order I make today as provided by law. Thank you.
First case on today's agenda, James Mark Civils. Case number 216-3043, Code Officer Alan Jonason. Page 20 on your agenda, Joanna Coutu, expert on the case.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you. Sir, can you please state your name for the record?
James Mark Civils.
Thank you.
Good morning.
Good morning.
Good morning. Alan Jonason, Citrus County Code Compliance Officer. This is case number 216-3043, Citrus County Land Development Code, Section 4002, Site Development without a development order or permit. The address of the violation is 4482 East Islet Court, Hernando, Florida. Property owner is Civils James Mark. I have good service via fine appeal, email request from the property owner, and posting on the property. This is a fine appeal from a case which was initially heard on 15 June 2022. On 15 June 2022, in a special master hearing, the respondent was found guilty and granted 90 days to abate the violation. If the violation was not abated, a penalty of $150 per day was ordered. An inspection conducted on 15 September 2022 revealed that the violation had not abated. A copy of the order imposing fine in the amount of $150 per day plus administrative costs of $143.79 beginning on September 15th, 2022 was sent via first-class mail, advising of the 20-day deadline to request a fine appeal. On 26 September, the respondent requested an appeal via email. An inspection on 14 October 2022 revealed that a permit was issued and the violation was abated. Therefore, the fine of $150 per day beginning on September 15th, 2022 through October 13th, 2022, which equals 29 days, amounts to $4,350 and should be recorded in the public record. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, a copy of the findings of facts and conclusions of law and order from the 15 June 2022 hearing, and a copy of the first order imposing fine. Exhibit B, photos from Exhibit A from the 15 June 2022 hearing. And Exhibit C, a copy of the email requesting the fine appeal from the property owner.
What's Exhibit B? Photos from the
Photos from
original Exhibit
yes,
A?
sir. Yes, sir.
Okay. We'll get into it, Mr. Civils. I guess I just ask you to look through these documents and let me know if you have any objection to them being evidence in the hearing.
Sure. How you gonna turn it over? I can't.
First hearing.
Okay.
Yes, sir.
Which we both agreed that.
Yes, sir.
Okay. These photos was the first
Yes, sir.
from June 15th?
Yes, sir.
Hmm. All right. Sorry about that.
Thank you, sir.
Do you have the, thing that shows the dates, everything was submitted, the summary?
It's just on the finding.
Okay, but you don't have. So you don't have the detail for the permit?
Are there any objections to these exhibits?
No, sir.
Okay. Then without objection, Exhibits A, B, and C will be admitted. Let me just take a look at them very quickly. I do remember.
Yeah, last time we looked at it, we both agreed that it looked like brush to both of us, but
Right.
I didn't take it no further.
All right, let me just take a look. Yeah, I remember agonizing over the photos a little bit. So, Mr. Sibbles, I guess what looks like happened is back in the June hearing, I issued a 90-day,
Yes, sir.
time period to comply. It
Right.
looks like Mr. Jonason went out and took a look at it to see if it had complied at the end of the 90 days. And actually, it looks like the county has more to say, so I apologize.
We do. No, that's okay. Joanna Cantu, Land Development. He's correct. The permit was issued on October 14th. The contractor has sent some passionately worded emails on why this took a while. This was a stormwater. There was a lot of items on the permit. I don't think he's incorrect. This was not a simple let's go pull a permit thing. So I think he worked toward it. I have no problem with no fine up to the October 14th because he has had it issued, and the tree removal now is addressed.
So the county has no objection to the appeal.
Land Development has no objection, correct?
Okay, well, do you understand what that means, Mr. Sibbles?
No, I do not. Do I owe money or not?
The answer is no.
Okay.
I mean, assuming I agree with, or, end up agreeing with the county that the appeal is well taken. I'm sorry?
The administrative fees.
Okay, the administrative fees. So in other words, the county still would assess the administrative costs, such as the $143 that is in the order, but nothing else.
Right.
Okay, so the amount that had accrued per day, the $150 per day from September 15th to October 14th or so, is going to, I'll end up sustaining your appeal and granting it, in other
Thank
words. But the administrative costs to comply with, that they had in order to deal with this, which is at least about $143, it looks like, that's going to remain.
Yes, sir.
Does that make sense?
I'm fine with that.
Okay, we'll issue an order to that effect. Thank you.
Thank you.
I should just pay the fine at the window, or
That's between you and the county.
where do I pay the fine at?
Mr. Civil, you'll be getting something in the mail.
Oh, wait, something in the mail?
Yes.
Appreciate it.
Next case on today's agenda, Donna Chirizio, case number 217-0426, Code Officer Amy Becker, page 6 on your agenda. Expert on the case, Joanna Cantu.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you, ma'am. Can you please state your name?
Donna Chirizio.
Thank you.
Good morning.
Good morning.
Amy Becker, Code Compliance Officer. This is case number 217-0426, a violation of the Citrus County Land Development Code, Section 3102A, accessory uses or structures. The address is 2039 West Most Lane, Citrus Springs, Florida. The property owner is Donna Chirizio. I have good service via posting of the property as well as the Lecanto Government Complex. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on August 5th. Photos taken on August 30th at my corrective action inspection. Photo taken on August 4th showing the posting of the property, and photos taken on my final inspection on October 18th. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, and a copy of the posting affidavit.
Okay. Ma'am, I'd like to ask you to take a look at these documents and take your time, but let me know whether you have any objections to them being evidence in this hearing.
No, sir. No objection.
Okay.
Thank you. Yes, ma'am.
And just for the record, and so I know, is there anyone from the public who wishes to speak on this case? All right, I see none. All right, without objection, what's been proposed as Exhibits A and B are evidence.
On August 5th, 2022, I observed 3 enclosed trailers, 2 sheds, and 1 tractor on vacant property, which is a clear violation of the ordinance listed above. As of my final inspection on October 18th, I observed 2 open trailers, 1 filled with scrap metal, 1 enclosed trailer, and 2 sheds on the vacant property. I have had contact with the owner, and she's aware of the violation.
Is there anyone else from the county who wishes to testify?
Yes, that's all right. Joanne Coutu Land Development, she did apply for a permit October 13th. I asked Building Division to rush it. They did just before this meeting. They said it is ready for pickup, and I think she's communicated to the Building Division, although she can speak for that, to pick it up tomorrow. So the permit is in hand, almost.
And
ready.
my understanding of the way it works is that money has to be exchanged before picking up the permit.
There is a fee for the permit,
Okay.
yes. That sounds
And-
really bad, but yes.
So is the violation abated or not?
Yes, it would be when she gets that permit.
But it hasn't been picked
Am I
up.
wrong? I apologize.
The
The-
home would have to be.
Well, she's got a unity of title with a house
Oh,
next
okay,
door.
I'm sorry.
So yes, once she gets that
Can
permit.
you explain that to me? So,
Because it's a vacant lot, you can't put a shed up by itself.
Right.
However, we have a process where if you have a house next door, you can fill out a form and say this is one development site.
I see.
She has that process in hand, so as part of the permit, she'll
She
have
owns
that.
the house next door.
She owns
I
a
see.
residence next
I
door. Yeah, so that'll
Okay.
clear it up. The permit can be issued, hopefully tomorrow, but it is ready for pickup.
Well, as a technical matter, there's still a violation because the permit hasn't been picked up, and so. But it sounds so, Mr. Terrizio. Here's the deal, and I want to hear from you, of course. But it looks like you've solved everything, and
I'm trying.
as of tomorrow, it sounds like or in a few minutes, whenever the permit's ready and you can pick it up and pay for it, the violation will go away. But because the evidence before me today is that the permit hasn't been picked up yet, I'm bound to follow the code. And so what I'm going to do is I'm going to find a violation, but I'll grant you 30 days to comply. Sounds like you can do it in one. So
Yes.
does that make sense?
Yes, sir. I didn't realize when I came in a couple of weeks ago, they told me it was gonna take some time.
Right.
So I wasn't prepared with cash.
Yeah.
I mean, I could use my credit card and pick it up today. I have no
I'm
problem
not.
with that.
It's not the case of the century, Mr. Terrizio. Again, it sounds like you've done what needs to be done to
I'm
fix the
trying.
issue.
Yes,
I'm just trying to. I'm basically apologizing to you that I have to follow the code
yes.
and find that there's technically a violation today. I'm going to grant you 30 days.
Okay.
You're going to be able to do it in one.
Yeah,
you
I'll
know,
pick it up
so
tomorrow.
we'll issue the order, and I assume that we'll find that you've complied with it very quickly. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
All right, the property is found in violation. I'll grant 30 days from today to abate the violation. All you have to do is pay for the permit. If the violation is not brought into compliance as ordered, a penalty of $50 per day would be imposed. That fine would be recorded and constitute a lien on your property. and you'd be required to pay all costs required by county law. Thank you.
Okay. All right, with picking up my permit, may I have like 6 months to complete this project?
That's
Okay.
Yeah.
All right.
that's beyond my authority.
Okay,
Thank you.
thank you.
Next case on the agenda is, sorry. Oh, yeah, she's gonna go talk to her. We'll do something. Next case on the agenda, Daniel G. and Sandra L. Tipton, case number 216-8439, Code Officer Jillian Nocella, page 22 of your agenda. Expert on the case, Joanna Coutu. No, sorry.
Mr. Tipton,
Oh, yes, ma'am.
do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name, sir.
Dan Tipton.
Thank you.
Good morning.
Good morning, sir.
Jillian Nocella, Citrus County Code Compliance Officer. This is case number 216-8439, Special Requirements for All Accessory Structures, a violation of Citrus County Land Development Code 3102A. The address is 6683 South Duval Island Drive in Floral City, Florida 34436. Property owner is Daniel G. Tipton and Sandra L. Tipton. Good service via signed certified mail return receipt. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A is photos I took during my initial inspection on July 19th, 2022, and follow-up inspection on September 15th, 2022, and photos from my final inspection on October 18th, 2022. Exhibit B is a copy of the notice of violation and a notice of hearing, copy of the signed certified mail return receipt, and also a copy of the property appraiser summary page reflecting the property is listed as vacant.
That's also in Exhibit B, the property appraiser
Yes, sir.
page. Sir, you've been watching. What I'd like to do is ask if you take an opportunity to look
Okay.
through these documents and just let me know if you have any objections.
Okay. Thank you. No objection at all.
Okay.
Thank you.
Just so I know, is there anyone from the public who's here to speak on this case? All right. Record reflect that there was no response. Thank you. Without objection, what's been proposed as Exhibits A and B are evidence.
I conducted my initial inspection on July 19th, 2022, and I observed a shed located on the vacant property. On September 15th, 2022, a compliance inspection was conducted and the shed remained on the property. As of my final inspection on October 18th, 2022, the shed still remains on the property and no permit for a residence has been applied for or issued. I have spoken with the property owner, Mr. Tipton. I spoke with him for the first time in August. He advised that they do intend to build a home on the property. The plans were still just with the architect.
Okay. Is there anyone else from the county who wishes to testify?
Joanna Coutu, Land Development, Coastal Lakes Residential, should be vacant. We have no principal use established.
And no record of permit application at this point?
Correct,
Okay.
as of this morning.
Okay. Well, Mr. Tipton, now I've heard what the county has to say. I'd like to hear what you have to say.
Okay, the shed was put on the property really just for maintenance of the property. We've got a couple mowers, a lot riding mower, regular mower, and also we've got tools in it that we're in the process, and I bought the property 3 years ago, and we're in the process of trying to pull a building permit. I had submitted paper application to Citrus County Building Department, and just about got through it. I got all the paperwork done and everything notarized right here at this building by Donna Harris, the lady that works in the building department. But unfortunately, the day my wife and I tried to submit the prints, they wouldn't accept the prints. There were some things missing on it, which needs to be revised by the architect and also by the engineers.
What's missing, for example? I mean, give me an example.
Well, for instance, I had a seal on my prints when I turned them in, but I needed to have a raised seal. I had a stamped red seal on it, which I thought would be okay. So when I took it back to the architect, they've got to make engineering changes as far as wind loads.
There
And
are
also-
engineering changes. It's
Yes,
not
sir.
just this seal
No,
technicality.
no, I
It's-
thought it was just, I thought when I was here talking to Donna, Mrs. Harris, that it was just that I needed to get the seal. But when I got back to the people that were going to take care of it, they said they couldn't seal it until they made some revisions in the plans.
Okay.
So, I mean, we had hoped to had the construction going by now, but we're still in the process. And I talked to Mr. Robian of Robian Design. That's the fellow that's working on the prints, and then he has an engineer that's also working on, and asked him how soon it would be. But he said it would be at least 60 days before they'd have them back to me because of the work they had going on, plus trying to get mine corrected. So realistically, I don't think I'll have the prints back to submit them to the county until like the end of December. He said the end of the year, but of course we're almost through October now, so it's a couple of months.
Right.
And he did tell me figure 6 to 8 weeks, but I want to make sure I can get them back and get the application to the county and get the building permit. As far as the building, I really didn't know I wasn't able to put the building there at the time, but I'm not, where my property, I don't know if this makes any exception to the case or not, but my property is located on back of my property line, and the north property line I have is 4,000 acres of agriculture. When I bought the property, there was cattle on my land. Mr. Fenton, the gentleman who owns all the property in that area, he actually fenced it off to keep the cattle out. So, you know, I really, as far as the storage shed, I maintain my property and keep the property up well. But like I said, the shed is just there for the tools. I live in Newport Richey right now, so it's sort of a convenient to have to try to get somebody to haul it. I mean, I'm not opposed to taking it out, but to spend the money and take it out and then put it back in a couple of months, that's what my problem is. I'm not opposed. Jillian, the code enforcement lady, has been very nice, and everyone in the process has been, you know, good to me. So I don't have a problem with anybody on it at all. The problem is the shed's there, and I don't have the permit pulled yet.
They didn't threaten to burn the shed down or anything like
No,
that?
not yet.
Okay.
No, I mean, obviously I have one neighbor that lives a couple blocks down the street that I guess she doesn't like. the
Clearly
shed being
someone
there.
didn't like it.
But
So,
other than that, I mean, in other words, my setting across the street from me, there are no homes. I have no homes to the north of me, have no homes behind me. I've got one home next to me, and that's not the
the
lake.
pictures are
Problem.
nice. I mean, it looks like a nice little landscape. But at any rate,
Right.
yeah, so it sounds, frankly, it's uncontested there's a violation. You understand why there's a violation, right?
Yes, sir. Yes,
Yeah.
I do.
So, have you heard anything that, you know, is incorrect or that has been misrepresented? Okay.
I mean, I filed I have all my papers notarized, or they were notarized right here as far as putting my building, my plans. And this, only reason I brought this was one of the original prints I brought with the seal, and I had turned in 2 prints, and I turned in this paperwork. But
Is there
and
anything you'd like to submit as evidence? Or...
if you need it, I mean, I made copies for you as far as having them notarized, and the day I tried to do that up here. But if you need them for any reason, you can have them. If you don't need them
If
for
you
any
have
reason,
copies, frankly, I think it's probably in your interest that they be introduced as evidence.
And also on the top sheet that I have, the cover sheet, is just a picture of the card of Robian Design, the people that are redoing the design work, and then the engineer I don't have the engineer's card, but he has an engineer that's going to seal it for us. But then I have the paperwork as far as.
Well, let me ask you to show those documents to the county, and I'll find out if they have any objections to those documents being evidence. I may or may not have questions about
Okay.
them. I think.
I mean, we want to go ahead and get started. We're almost 9 months behind as far as
yeah,
a lot of things that's happened in the last year and a half, and you know what they are. That as far as
Well,
different things
you
going
know,
on, but-
there's a violation here.
Right.
The only question in my mind is how much time.
Right.
You know, and I will provide time, but the only question is how much.
Okay.
And I'm very interested in what the county has to say in reviewing some of these documents.
Okay. Actually, it was the end of June when I tried to pull the permits and then had to take the prints back.
Sure. Are those other documents you have? Are those copies or are those originals? Or
This is just one. This is actually just one of the blueprints of the house that I brought in originally.
Could we
But-
take a look at those? While
Sure. Yeah. But did you have any objection to these? Okay. Then without objection, these will be, let's say, respondents A. I'll just take a quick look through them.
very
Oh, did you record the notice of commencement?
No, sir.
No.
I could get the notice of commencement without getting the permit.
I think that's his application, but it wasn't it hasn't been accepted by the
Right.
Okay.
building department.
Okay.
The day we were here, when the lady helped us, matter of fact, we had the paperwork done, but we didn't have it done properly. She went back through it and helped us do the
Wait.
paperwork and notarized it. And then we thought we were done with the process, and she got to look at the prints and said, need to have a raised
Well,
seal.
you'd be
on it.
amazed. You really don't need anyone's permission to record a notice of commencement as long as it's notarized. But
It's good enough for us.
Oh, it is, except for the wind load thing that he's waiting for.
Oh, and the wind load, all that they were talking about was what type of windows I had to put in, if I was to put hurricane shutters or storm windows. So that wasn't noted on there that I remember, and that was really the only thing that I needed on the storm load.
Stormwater, did you need stormwater plans?
No, ma'am.
You're not in a flood zone?
No.
Okay.
I'm on, actually I'm on Duval Island, and I'm not in the floodplain.
Yeah, most of Dubai is where without it, and it's not that good for you.
These aren't sealed.
Oh,
With
that,
the
yeah,
sealed
that
cell
was the
plans,
thing about
We
the,
would take it in.
well, I'm not going. Thank you for letting the county review those documents. I'm not going to require them in evidence or ask you to give them to me. How much time do you think you need to? Well, what would it take to abate the violation? The issuance of a permit or the actual completion of construction?
The issuance of the permit for a single family.
Okay.
And yes, for the shed to be included.
How far away, Mr. Tipton, do you think you are of being able to provide the county everything it needs to review an application for the permit?
I think it'd be no problem in 8 weeks, but from what I understood, I needed to have the permit pulled. So I mean, then I think
You do need the permit pulled, but what I'm
Okay,
curious
90
about is
days.
how long it'll take
Okay.
you to get the application in.
Mr. Robian did tell me it would be 6 to 8 weeks, so I'd say at least 8 weeks because I don't want to come back here a week late or something like that. Or, I'd like to go ahead and make sure I've got the time.
No, 8 weeks won't be enough because the
Yeah.
county has
Right.
to review things, and they
So-
may have more feedback.
Yeah.
I don't know.
So 90 days would be, I think, sufficient if I can do that.
About how long do you think it would take, assuming that the application came in and didn't require more review? How much time do you think it would take to review?
Our building official, who I don't think has been sworn in
No.
yet.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir.
Realizing you're not promising anything, but just a guideline.
I would say if he can get his package into us in 2 months, a good package can be processed easily in 2 more months. I'm not opposed to 4 months.
Okay.
And I would think also at the time that he's approaching his deadline, if everything is very, very close and we don't see much of a delay,
Right.
we would be willing to work with him.
And just this would have to also include the shed. The house itself is not gonna fix things. You'll need a shed permit as well if that shed's gonna stay,
Oh,
because that's
okay.
your violation, is the shed.
Well, actually, the shed won't, once I get the house built, I won't have the shed there. But if I wanted to keep it, I would apply for an
You're going to
application.
move the shed once the.
Yes.
Okay. Well, look, there's 2 ways to abate it. One is to remove the shed or to get the permit. And I don't see any health sanitary issue with the violation. So instead of giving you a timeline regarding just removing it, I'll give you a timeline for being able to get the permit. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with the administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owner once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I will find that the property is in violation, but I'll grant 5 months from today, or from the order to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and constitute a lien on the Tipton's property. County Attorney's Office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the owner shall be responsible to pay all costs required by county law. Thank you.
I had one question for the building officials.
The hearing wouldn't be the appropriate
Oh,
forum
okay.
for that. Yeah,
All right, that's no problem.
I encourage you to get in touch with the county later.
Okay, thank you. I
Thank
appreciate
you.
your help.
Yep.
Next case on the agenda, Stephen L. Spry and Olga Kalashnikova, case number 217-0445. Code Officer Amy Becker. Page 21 of your agenda. Expert on the case, Carl Jones.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. State your name for the record, please.
Stephen Spry.
Thank you.
Amy Becker, Co-Compliance Officer. This is case number 217-0445, referred to Code Compliance from Licensing after the fact permit, a violation of the Citrus County Code of Ordinances. Chapter 18, Article 1, Section 18-8A. The address is 4355 West Denellen Road, Denellen, Florida. The property owner is Stephen L. Spry and Ogla A. Kalavashkinova. I have good service via posting of the property as well as the Lecanto Government Complex. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my inspection on August 5th, 2022. Photos taken on October 7th, showing the posting of the property. And photos taken on my final inspection on October 18th. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, and a copy of the posting affidavit.
Okay. Sir, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence.
They let you on their property. No, I don't have any, Amy.
Well, take your time.
No, it's okay.
Is there anyone from the public who's going to want to be heard on this case? Okay, let the record reflect that there's no response. Without objection, exhibits A and B are evidence.
On August 5th, 2022, I observed an aluminum screen room on the back of a single-family residence. Upon arrival back to the office, I checked the Hanson application and did not find a permit, which is a clear violation of the ordinance listed above. As of my final inspection on October 18th, there is still no permit for the screen room. I have had contact with the owner, and he's here today.
Okay, and when did you previously have contact with the owner?
August 16th, the owner called and I advised him permit was needed for the room. September 1st, both owners met with the building department as far as permitting. And October 4th, Mr. Spry called, advised that he met with an engineer, and he will be submitting for a permit. But I'll
Okay.
let him testify.
Okay, well, first, is there anyone else from the county who wants to testify?
Oh, sorry, yes.
Carl Jones, building official, Citrus County. I just want to say that a permit is required for an aluminum screen room. It's a specialty structure and requires at a minimum a specialty contractor to build it.
Okay, thank you. doesn't look that bad from the photos, but you know, the law is the law. So what's your perspective on this, Mr. Spry?
Well, it was pre-existing. A lot of it was. I've done some improvements to it. It was on the tax roll. Not being familiar with the state of Florida and the tax roll, I assumed that everything was okay when I bought the place. And
Well, now hold on a second. So when did you buy it?
I bought it in May of 2018.
Okay. So here's the thing about something that's pre-existing. It may be that the seller should have disclosed that to you, or the seller before them to your who knows. If it pre-existed the Florida building code, then the county may not be able to hold you responsible for that. I don't know. It's possible, but we don't know. I mean, it looks a lot newer than when the Florida building code was enacted.
Well,
so.
we've cleaned it up and replaced some boards and stuff.
Yeah.
But, any rate, I hired Southern Home and Design in Ocala. They came out and did measurements. Right after I talked to Amy, I can't remember the day, like the next day or something. And they were supposed to have all my engineered drawings and everything last week.
Did they come out?
They actually came out and spent quite a bit of time there crawling under, over, around, in, and out, and taking measurements.
Okay.
And I was supposed to have engineered drawings last week.
Oh, yeah.
And they keep saying, nope, not yet. I don't know whether the hurricane put them behind or what.
Okay.
But I am in the process of drawing a permit. And
Okay.
I can't say, because I can't speak for these people, I don't know how long it's going to be before I get the engineered drawings to submit for the permit.
Although it's been represented to you that you should have them soon.
Correct.
We don't know, but that's what they've said.
Yeah.
Okay. For something like this, assuming that, the engineering plans were received, let's say, 2 weeks from now, how long would it take for the county on average to review these kinds of things?
1 month.
1 month. Now, in the alternative to getting an after-the-fact permit, what would he have to do to abate it? Bulldoze it? Get a permit to bulldoze it?
Demolish it.
Demolish it, yeah.
Remove it.
But you need a permit for that too, right?
No.
No?
No. For corrective action to remove something that was built without a permit, we just ask them to remove it.
Wow. Okay.
We try to not beat them up too badly.
What I'm inclined to do, Mr. Spry, is probably give 2 months.
I'm
2
sorry.
months?
Two?
Yeah.
Okay.
I realize that it's a little bit out of your control as to when you can get the plans, but it's represented you might be able to even get them in a week, right?
Right. Yeah, I don't know. They keep saying another week.
What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day, along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owner once they were advised of the violation, and this amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I'll give a little bit more time than 2 months just because I don't want either your back against the wall or the county's in reviewing it. So I'll find that the property is in violation. I'll grant 3 months from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. That fine would, constitute a lien on your property ultimately, and if it's not paid within 3 months, the county county attorney's office may seek foreclosure or money judgment on any unpaid lien 3 months from the date of first recording. You also would be responsible for any other costs assessed by county law.
Okay.
All right, that's it. Thanks.
Okay. Thank you.
Next case on today's agenda, Rick and Richard Romeo and Marlene Juliet Gatson. Case number 212-6306, Code Officer Jillian Nocella, Page 19 of your agenda, expert on the case, Carl Jones.
Jillian Osella, Citrus County Code Compliance Officer. This is an appeal at the request of the property owner, Richard Romeo, in reference to an unsafe structure and an order to demolish of the residence. Case numbers 212-6306, Unsafe Structures and/or Conditions, Chapter 20, Article 5 of the Citrus County Code of Ordinances. Correct.
Since the
He's not here.
person who wants to appeal the demolition order isn't here, should we be required to present a case?
Yes. I think the burden, well, I don't know. And so I guess I want to hear first, review the code, and we'll see.
Okay. You want me to just continue with the
Yep,
rest of
just
the
like you
information?
would.
The address.
Maybe I'll dismiss the appeal, maybe I won't. But I want to look at the code and hear
Okay.
what you have to say.
Sure. The address is 9521 East Atkinson Court in Floral City, Florida, 34436. Property owner is Rick Romeo, Richard Romeo, and Marlene Juliet Gaston. And I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A is photos taken during my initial inspection on October 20th, 2020. Photos taken at a subsequent inspection on October 11th, 2021 and October 5th, 2022. And photos taken at my last inspection on October 18th, 2022. Exhibit B is a copy of the order to demolish, a copy of the safety evaluation inspection report, photos of the unsafe structure abatement notice posted on the property on August 1st, 2022, and my posting affidavit. And Exhibit C is a copy of the courtesy letter sent to the property owner informing them of the violation, and a copy of the letter sent to the property owner informing them of their requested appeal date and time. Also photos of the appeal request letter posted at the property.
Is there anyone from the public who wants to be heard on this case? Okay. All right. Without objection, what's been proposed as exhibits A, B, and C are evidence. I'd just like to look through it very quickly. I'm normally inclined to hear these just because I consider them the most serious cases that come in these hearings. Is there a copy of the request for the appeal in here?
I do not have that copy. I could get it if you wanted to.
Do you know what it says?
It was a letter that was hand delivered. It wasn't specifically stating he wanted an appeal, but
You
kind
construed it as an
of
appeal.
insinuating yes. So
Yeah.
to be on the safe side, we just went ahead and
Okay,
gave him an appeal date.
I see. I think that's the wise course. Do you know if there are people living in it right now?
It doesn't appear as if anyone is there currently. When I did my initial inspection, I was given access to the property by a current tenant at the time. I don't know how long after she moved out.
Did they have a lease? Do you know?
I don't remember. I don't recall.
So the safety evaluation report and recommendation seem a little older, between October and December of 2020. Well, does the county wish to introduce this in evidence? I mean, I'd like to have it in evidence. I'm now holding a copy of the letter from Richard Romeo. Do you have any objection to that?
I don't, as long as.
I don't think we want to introduce it into evidence,
Yeah.
but we have no objection.
Okay. That's what a lawyer does. A lawyer represents. So let me just look at it. I think the county fairly construed this as at least a request for a hearing, but the actual order to demolish, when was the order to demolish signed? This was signed on July 20. Okay, so they did send it in response to the order, basically. It says on the order to demolish, if you request a hearing and do not attend the hearing or do not show good cause, the county may take action to cause the demolition or removal, including court action against you, and may seek reimbursement for costs. Okay. The safety evaluation report and recommendation appears to have recommended an order to vacate and order to demolish by December 28th, 2020. I am going to admit the letter as evidence as respondents A, and I'm just going to quickly look at the code sections. I may or may not have any questions. So I assume the county is saying that it's blight.
We have it for slum. J.C. Charlton signed the order.
Okay, I did see that. Okay, so
addressing
it's a
it.
slum.
Yes.
Okay. The appeal is dismissed.
Thank you.
Next case on the agenda. Gary Moore, case number 216-8251, Code Officer Matt Hampton, page 15 of your agenda.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Please state your name for the record, sir.
Gary Moore.
Thank you.
Good morning.
Good morning. Sir.
Matt Hampton, Citrus County Code Compliance Officer. This is case number 216-8251. Accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 6453 West Arter Street, Crystal River, Florida. Property owner is Moore Gary. Good service via posting of the property in the Lecanto Government Building. I would like to authenticate the documents and request that they be admitted into evidence. Exhibit A is photos I took during my initial inspection on July 20th, 2022. Photos I took during my corrective action inspection on September 12th, 2022. And photos I took during my pre-hearing inspection on October 18th, 2022. Exhibit B is a copy of the notice of violation, a copy of the notice of hearing, a picture of the notice of hearing posted at the property, and a copy of the posting affidavit I completed on October 6th, 2022.
Okay. Sir, I'd like to ask you to just take a look at these documents and let me know if you have any objection to them being actual evidence in this hearing.
No, I don't oppose it.
You don't have any objection?
No, this is all new to me.
Okay.
I just got back in town. I was busy at work.
All
My
right.
brother he actually been staying there since my father passed away, so.
Yeah.
It's on. I'm just
I hear you.
working. I'm missing work to be here. So.
Right.
Obviously, my pictures of me ain't in there.
Well, I'll give you an opportunity to explain whatever you can.
Yeah, it's all new. I got this finally. Got this
All right.
just yesterday.
All right. So without substantive objection, what's been proposed as Exhibits A and B are evidence. Is there anyone from the public who's going to want to be heard on this case? Okay. Well, I'll call you up. I just want to know that you're there and want to say something. All right, go ahead.
I conducted my initial inspection on July 20th, 2022 for the ordinance listed above. I observed the property to be in violation. There was scrap metal, automotive parts, furniture, trash, and other junk and debris spread around the property. I conducted my corrective action inspection on September 12th, 2022. I observed some progress. I posted the property in the Lecanto Government Building with the notice of hearing on October 6th, 2022 for good service. And I've had no contact with anyone regarding this property. And as of my pre-hearing inspection, there was little change. There was a couple trailers that had been taken away, but other than that.
So on page 5 of 9 of Exhibit A, I see someone there. Do you know who that is?
No, sir.
Okay.
I
They didn't even respond to me.
You do?
That's my little brother. Both of my brothers was staying there since my father was sick. He died there at that house. So we're all still in a little bit of a depression, I guess you would call it.
But you're the owner?
Yes.
Okay.
They was helping me take care of my father there.
Okay. When did you become the owner of the property?
I became the owner of property back in 2000 and I think 18,
Gotcha.
17.
Okay.
I've been there almost 10 years. And it was never like this. It was never like that. I mean, I let them stay or whatever they do.
Where do you reside or?
I live there, but I constantly work. I travel for my job.
I gotcha. Okay.
When my father passed away, I traveled more
Mm-hmm.
because it was no sense of me staying home like that. And then I let them take care of it. Apparently,
May I ask when your father passed away?
September 19th,
This year?
last year.
Last year. Okay.
My mom's in the hospital now over the same thing. She's dying also, literally in Citrus Memorial.
Well, I mean, you've got an issue.
Yes.
It
I'm
does
trying to
look
fix
like
it.
there's a violation. It looks like there is the junk there. You've seen it.
Yes.
There's photos here. How much
will.
time would it take you to fix it?
Give me some time. I don't know. I know that since I've been home, I've been talking to him about it. That's one of my brothers right there.
Okay.
And told him I'd help him, but they have to get it together. So, I mean,
I mean, it's not something that can be done overnight.
No, and it's gonna be a finance thing, you know, it's financial, I'm still paying some of my dad's, funeral expenses and all that, and this is almost a year later, so, I still need help there, so it's,
Well,
as long as the county can work with me in the state, then I will work with them.
sir, would you like to come up, be sworn in, and tell us what you'd like to say?
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
And your name, please?
Michael Moore.
I'm
Thank you.
sorry?
Michael Moore.
Thank you.
So, what would you like to?
No, it's my fault.
Okay.
That's it.
All right. It's how much time? I mean, would you be able to help clean it up?
I can have it cleaned up in a week.
Okay. I mean, is 30 days enough?
Yeah. I would say more than that, 'cause it's gonna be a finance thing too.
Okay.
We're gonna need money to go to the dump and all that.
That's true.
I would say a little more than just.
What about 60 days? I mean, I can do 60. Okay.
90, that'd be fine with me.
What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with the administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask the special master additionally fine it as the respondent's responsibility to contact the Code Compliance Division when the violation is abated in order to allow for reinspection.
Do you have any other pending cases on this property?
I did. I had an unlicensed inoperable vehicles, and they had that taken care of.
That's what that's what it looked like to me, so
Yes,
I
sir.
figured I'd ask. And that might impact what I do in terms of the amount of time as well. Well, it looks like there's been some progress made already. So it looks like you're working towards it. You've admitted to the violation. So what I'll do is I'll find that there is a violation on the property. I'll grant 90 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine would be recorded and constitute a lien on your property, Mr. Moore. The county attorney's office may seek foreclosure or a money judgment if such lien hasn't been paid within 3 months of recording, and you would be responsible to pay all costs required by county law. But I think that should be enough time. Okay? Thank you very much.
Thank you.
Next case on the agenda, Brandon B. Brooks, case number 216-9885, Code Officer Jillian Nocella. Page 5 of your agenda, experts on the case, Joanna Coutu and Carl Jones.
Jillian Nocella, Citrus County Code Compliance Officer. This is case number 216-9885, residential accessory uses of violation of Citrus County Land Development Code 3101I. The address is 9304 East Crescent Drive, Inverness, Florida 34450. Property owner is Brandon B. Brooks. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A is photos I took during my initial inspection on July 26, 2022, and at my corrective action inspection on July 26, 2022, and my corrective action inspection on August 26, 2022, and my final inspection on October 18, 2022. Exhibit B is a copy of the notice of violation and a notice of hearing sent to the property owner, and a copy of the signed certified mail return receipt.
Okay. Is there anyone from the public who's going to want to be heard on this case? Okay.
I know, so what's the deal? I know, but they haven't done anything about it.
Okay. Thank you. Without objection, what's been proposed as exhibits A and B are evidence.
On July 26, 2022, I conducted my initial inspection and I observed there to be no barrier around the in-ground pool, which is a violation of the code listed above. Corrective action inspection was conducted on August 26, 2022, and I observed a privacy fence to be partially installed. However, it was still not encompassing the pool or even the total backyard. And as of my final inspection on October 18th, 2022, the property remains in violation. There's still no barrier around the pool. On October 11th, 2022, a permit was applied for. It stated it was to add additional covering to the rear lanai area. However, the plans did not seem to address a pool barrier at all.
Do you need a permit to put in the appropriate barrier under the code? Or a barrier that would satisfy the statutes and the restrictions,
Right,
requirements?
Joanna Coutu Land Development, depends on what they're choosing. If they're putting up a fence, no. If they choose to reinstall a pool enclosure, yes.
A what enclosure?
A pool enclosure.
Oh, meaning like a screened in.
Right, the aerial show there was one there in 2019. In 2021, aerial, it's gone. So that would meet it if they could do that with the locking door thing, or a fence, like she's talked about. But a fence does not require a permit.
Would an enclosure comply if it doesn't have a separate barrier between the pool and like the screen or the house door?
It's meant to have kids crawling into it. There's not that safety from the house. I know what you're talking about, but it's meant for outside kids coming in.
I see.
Is the
Neighbors,
land development code, right? There
guests.
might be something in the building code as far as the safety of the house occupants, but this is for outside.
And is this house in a regular neighborhood?
It is, and it's
And that's not vacant land, these are all lots in a suburb.
correct. It's a house area
So any
with
child could crawl into that, get into that yard, wander into the yard and fall in the pool.
Yes, ma'am.
I mean, I think the only exception I'm aware of under the Florida statutes, and I'm willing to hear from the county, is if the house or the pool was installed prior to the requirement, then it can be grandfathered in. But based on the testimony that I've heard, it was already enclosed and now it's not. So anyways, does the county have any other testimony it wishes to offer?
I'll just throw a little more information in there. Based on the date of the construction of the pool, a legal pool safety barrier would have been in place for final inspection.
Right.
The local ordinance requires that barrier be maintained in accordance with the requirements of the Florida Building Code, original requirements for the pool safety barrier, so we would require a permit to install it. The barrier is required to protect the pool from intrusion from outside the yard, as well as intrusion from the home. There's two aspects to the Pool Safety Barrier Act.
That's what I'm worried.
There are two aspects to it: one, protection from intrusion from the home, and one from the outside.
So I guess that's what I'm wondering. How does it protect from intrusion from the home if it's just like a screen porch that connects to the home?
Right. Any window or door that's adjacent to the pool enclosure, the home constitutes the barrier. Any of those windows and doors would have to have an alarm on them so that it sounded when the door is open or window is open, or there's a provision, an exception to that code, which would require a floating alarm in the pool, so that if anybody leaves the home and goes into the pool, disturbing of the water would set off the alarm. It's an extensive code.
No, I've read it. I read it before the hearing, to be honest, so I could familiarize. I just didn't know if I could believe it.
It's real.
But you've just told me exactly what I thought I read. Those are very. I understand it's for the health and safety of the people. It's just those are very high restrictions.
Exactly. Now, Ms. Coutu was absolutely correct that under normal circumstances, installing a fence would not require a permit. However, installing a fence that meets the requirements of the Pool Safety Barrier Act, there are other additional requirements in there that I believe we would require a permit for it, such as self-closing, self-latching gates where the latches are higher than 54 inches above grade. The fence has to be non-climbable. That means even if it's a chain link fence, the standard 2.5 inch opening found in a chain link fence doesn't qualify. You have to drop it to a 2 1/4 inch opening chain link.
Back in 1900, barely any Americans could swim, and it makes sense. I mean, but it's Florida.
They didn't have big round pools either then, so.
Right? Yeah, that's right.
Also the number one cause of death of children.
I know. I can't argue with that. So I also can't argue with the law. So I guess, have you had any contact with the owner?
I did, yes.
And what did they say?
When I spoke with him, he did insinuate he had plans in the works for some type of project around the pool area. I just reassured him it needed to include that safety barrier for the pool and meet those requirements. The permit, my understanding, what was submitted,
It's insufficient.
correct, at least in regards to the pool barrier. Whatever else he's doing with the lanai is one thing, but
Sir, I'd welcome your input. I know you want to speak on this case. So what you'd have to do is probably come up to the microphone and be sworn in.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And your name, please?
My name is John Lane.
Thank you.
Thank you, sir.
I live next door to the property. I've asked him to put an enclosure around his pool. He tore it down. They did renovations on it. I understood that. When they got through with the renovations, they did not put the pool enclosure back up.
Do they just not want to put it back up, or do you know why?
I have my opinions, but he's a contractor.
Mm-hmm.
They kind of do their thing,
Well, they had an opportunity to be here. I'm interested in what your perspective is.
Yeah. My personal thought was his arrogance.
Okay.
We're just not going to do it. And, I've asked him to put it back up. I have two granddaughters. They're 2 and 3. They come over and spend the weekend.
And they can escape.
They can escape.
Yeah.
The 2-year-old, man, she takes off. And she has run toward the pool. We've caught her. We do our best not to let either one of them out of our sight. I realize it's our responsibility for their safety. But I also feel like it's his responsibility to follow the law.
And he's a contractor.
The state statute
Yeah.
says he has to have a pool enclosure.
Yep.
And he refuses.
Okay.
And what he'll do is he'll start a project, make it look like he's going to do something, and then he just stops.
Are you referring to the
I'm referring to the
application that
fence.
I see.
I also had a problem with him with his loud airboats, driving them up into the yard, like 50 feet from my house, with putting the, revving up the RPMs as high as they would go. The loud music from his parties. I asked for a fence. And so he puts up a little fence that just blocks off my house from his, but it doesn't even extend into the backyard. And, that's probably not a code violation. I don't know that it is, but enclosing the pool is a code violation. And it's my request that you enforce that code.
Thank you for your input.
Okay.
All right. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $200 per day along with the administrative cost to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I adopt the county's proposed findings of fact. The property is in violation. The owner will be granted 30 days from today to abate the violation. 30 as opposed to a longer period due to the information that's been provided that it could be an actual health issue for safety issue for the neighbors and grandchildren. If the violation is not brought in compliance as ordered, a penalty of $300 per day will be imposed. This fine will be recorded and constitute a lien on the owner's property. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the owner shall be responsible to pay all costs required by county law.
Thank you.
Thank you.
Next case on the agenda, Lydia L. Walters Dunn, case number 216-8114, Code Officer Matt Hampton. Experts on the case, Carl Jones and Joanna Coutu.
Morning again.
Morning.
Matt Hampton, Citrus County Code Compliance Officer. It's case number 216-8114. Construction or modification of a structure without required permits. A violation of Chapter 18, Article 1, Section 18-8A of the Citrus County Code of Ordinances. The address is 5028 South Grand Circle Terrace, Homosassa, Florida. Property owner is Dunn Lydia L. Waters. Good service via posting of the property in the Lecanto Government Building. I would like to authenticate the documents and request that they be admitted into evidence. Exhibit A, photos I took during my initial inspection on July 13, 2022. Photos I took for the corrective action inspection August 29, 2022. And photos I took during my pre-hearing inspection on October 18, 2022. Exhibit B is a copy of the notice of violation, a copy of the notice of hearing, a picture of the notice of hearing posted at the property, and a picture of the posting that I completed on September 8, 2022. And then there's a copy of the continuance letter, a copy of the posting affidavit, and a picture of the continuance letter posted at the property October 6, 2022.
Is there anyone from the public who's going to want to be heard on this case?
Thank you.
Let the record reflect there's no response.
This property? That's next door, okay.
Without objection, what's been proposed as exhibits A and B are evidence.
I conducted my initial inspection on July 13, 2022 and observed the property to be in violation of the county ordinance listed above. There was a second mobile home on the property without permits. Corrective action inspection was completed on August 29, 2022. I spoke to the property owner, Lydia Dunn, on September 12, 2022 and advised her to show up to the hearing so she could testify on her behalf. Told her to show up to the hearing on September 21st, 2022. On September 14th, Mrs. Dunn spoke to Lori Spiros, Code Legal Secretary, requesting a continuance, which was granted and which put this case on this October 19th, 2022 hearing. I posted the continuance letter at the property October 6, 2022. Mrs. Dunn came into the office on October 17, 2022, and spoke with Joanna Coutu, Land Development Director, and myself on the steps she needed to take to try to get the second mobile home permitted. Mrs. Dunn advised that she would not be able to attend a hearing due to a conflict of schedule with a court hearing she had. As of my pre-hearing inspection October 18, 2022, the mobile home remains on the property and no permit has been issued or applied for.
So she has one on the property that she's allowed to have, but the second one doesn't have any kind of a permit or?
Yes, sir. I looked in our property appraisers app. We're able to look at the patch with pictometry, and it looks like sometime between 2010 2012 when the property was owned by her grandfather, he brought it onto the property.
I gotcha. Okay. And now she's the owner. Did he deed it, or do you know?
I don't know.
Okay.
I do not know, but she is the owner.
All right.
Joanna Coutu Land Development, we did, Matt and I met with her on Monday, the 17th. She said that a now deceased family member had that installed, and the mobile home installer is no longer in business. So told her the outline for a permit, went over to the health department, checked health records. They didn't pull any well and septic hookups either for it. So she's going to go to some of the mobile home installers and try to find one that can help her pull a permit after the fact to keep that there.
Wow. Okay. I mean, are people living in this second home? Do you know?
They may be able to have the second because she said it was small enough to qualify as a guest house. That's 850 square feet of living area. She says it's less. You don't know. Having no plans, no idea, right? I don't know about people living there.
But basically, what you're saying is that it's theoretically possible, assuming that's accurate.
Correct.
But I guess, do you know if anyone's living there right now?
It does appear that somebody is living there because every time that I've been by the property, there has been a vehicle parked in front of or adjacent to that home.
Okay.
Is it hooked into septic?
We don't know.
According to the health department.
There's no permits for well and septic for that particular site. They're so close to the existing mobile, they may have been able to connect, but they didn't pull permits to do so.
I see 2 experts listed. Does anyone else wish to testify? No? Okay. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with the administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask the special master additionally fine it as a respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I adopt the county's proposed findings of fact. The property is found in violation. The owner is granted 5 months from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on the property of Ms. Dunn. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and Ms. Dunn will be responsible to pay all costs required by county law.
Thank you, sir.
Next case on the agenda, James Head, case number 216-4445, Code Officer Matt Hampton. Page 10 of your agenda. Expert on the case, Joanna Coutu.
Morning.
Good morning.
Matt Hampton, Citrus County Code Compliance Officer. Case number 216-4445, temporary occupation of a recreational vehicle, violation of section 3140 of the Citrus County Land Development Code. Address is 6809 West Pershing Drive, Homosassa, Florida. Property owner is Head James. Good service via posting of the property in the Lecanto Government Building. I would like to authenticate the documents and request that they be admitted to evidence. Exhibit A is photos I took during my initial inspection, May 11, 2022. Follow-up inspection conducted on July 26, 2022. Photos I took during the corrective action inspection, September 8, 2022. And photos I took during my pre-hearing inspection on October 18, 2022. Exhibit B is a copy of the notice of violation, a copy of the notice of hearing, a picture of the notice of hearing posted at the property, and a copy of the posting affidavit I completed October 6, 2022.
Is there anyone from the public who's going to want to be heard in this case? Let the record reflect there is no response. Without objection, what's been proposed as Exhibits A and B are evidence.
I conducted my initial inspection May 11, 2022 and observed vehicles and personal possessions around the travel trailer, given the appearance that the travel trailer was occupied. At the time of the inspection, I did speak with the property owner, Mr. Head, and his mother, who both confirmed somebody was residing in the travel trailer. I advised that they could not live there indefinitely and would have to vacate it after 14 days. Mr. Head said he understood and said they would get it gone in a week. I conducted a follow-up inspection July 26, 2022 and observed little change. I spoke to the property owner's mother again at that time, and she advised me that her son said that he did not care what the county said and he was going to do what he wanted to, that it was not going, there was nothing that I could do about it. Corrective action inspection was conducted September 8, 2022, and I observed no change. As of my pre-hearing inspection, the SUV is gone. However, the motorcycle was still parked in front of the travel trailer and it still appeared to be occupied.
Well, what was your response when she said that he doesn't care what the county wants?
I just said that he'll be getting a notice of hearing in the mail.
That's very professional.
She said something vulgar and
I like to get a flavor for the conversation. What did she say?
It's about fucking time.
Okay. Oh, like she thinks
she wanted him to go to hearing.
Okay.
Yes.
And have you had any further contact with him or?
Not him, no.
Okay.
I have had multiple times with her. She's usually sitting out on the front porch.
Okay.
And cheering me on as I take pictures.
Okay. Is there anyone else from the county who wishes to testify?
Joanna Coutu Land Development. It is medium density residential with mobile homes allowed. There is a mobile home on the site. On the 2019 aerials, this RV is not there. On the 2021 aerial, it shows up in this exact spot.
Okay. Let me just take a look at the table, refamiliarize myself with it very quickly. Okay, what's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $200 per day along with the administrative cost to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask the special master to additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation is abated in order to allow for reinspection.
I adopt the county's proposed findings of fact. The property is found in violation. The owner is granted 30 days from today to abate the violation. If the violation is not brought in compliance as ordered, a penalty of $300 per day will be imposed. This fine will be recorded and will constitute a lien on the property of Mr. Head. County Attorney's Office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the owner shall be responsible to pay all costs required by county law. Thank you, sir.
Next case on the agenda, David A. Peruzic, case number 2170754. Code Officer Alan Jonason, page 16 of your agenda. Expert on the case, Joanna Coutu.
Is this the third or fourth straight hearing we've had with Mr. Cruz? I mean, does anyone keep track of these things? Is there a record or?
Unfortunately, yes.
Okay.
No, the RV is closed. Alan Jonason, Citrus County Code Compliance Officer. This is case number 2170754, section 3102B of the Citrus County Land Development Code, special requirements for all accessory uses. The address of the violation is 122 North Cedarview Terrace, Inverness, Florida. Property owner is Perusek David A. I have good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during an initial inspection on 9 August 2022. Photos from a compliance inspection on 12 September 2022. And photos of my final inspection conducted on 18 October 2022. Exhibit B, a copy of the notice of violation, copy of the notice of hearing, a copy of the posting affidavit, and a photo of the notice of hearing posted on the property.
Is there anyone from the public who's going to want to be heard on this? Let the record reflect there's no response.
Who they were living in the RV, right?
What was that, Ms. Becker? Oh, okay. Well, that's actually a good point. Without objection, what's been proposed as exhibits A and B are evidence.
On 8 August 2022, I conducted an initial inspection and observed the property to be in violation. The occupants of the shed and the garage admitted that they were living inside the structures. On 8 August 2022, a notice of violation was issued for occupancy of accessory structures, which is a violation of the ordinance listed above. On 12 September 2022, I conducted a compliance inspection and observed that the property remained in violation. I have had contact with the property owner, but as of my final inspection on 18 October 2022, the property remains in violation.
What did the owner say?
The same thing he said all the other times. I'll take care of it.
Okay. Do you have any other open cases right now with him?
Not open, but I have 2 others that were initiated by the Citrus County Sheriff's Office for junk and debris, as well as unlicensed vehicles.
And these are cases I haven't heard?
You have heard.
I have heard,
Yes,
okay.
sir.
But there's nothing else in the hopper, so to speak, that...
Not yet.
Not yet,
Not
okay.
yet, sir.
Can I ask a question about those cases?
Please.
And did those cases close with liens being recorded on
Yes,
the property?
fines were recorded.
Mm-hmm. On the other hand, it looks, it doesn't look that bad in there. And
I said the same thing.
And do you remember the Barefoot Bandit?
I do not.
It was this like 17-year-old kid who was going around the country stealing airplanes, and they called him the Barefoot Bandit because they would find his tracks of his bare feet in like the snow.
Oh, no.
And he got away with it for a long time. And yes, technically what he was doing was illegal, but how cool was it, you know? And
Can't fault him
you
for that.
you can't help but root for the Barefoot Bandit. No, I'm not saying that's cool. I'm saying, you know, I kind of, you know, there's a grit here. There's a grit.
I will just say that is the nicest setup in a shed
Right.
that I've ever seen.
Yeah, I admire it.
Yeah.
And it's illegal. What's the county's recommendation?
Go ahead, please, Joanna.
We don't know about the shed either. There's no permit at all. We know about a barn. We know about a detached garage, which apparently might be occupied too. But the shed, we don't have any permits for at all.
Which may be another.
I
We may be back.
What is the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day along with the administrative cost to begin after the date you deem sufficient to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to the violation. We would also ask the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
You know, when I was a prosecutor, there was someone who often appeared in front of me for misdemeanors. And gosh, it was misdemeanor after misdemeanor. There must have been dozens. And he kept finding a way to get away. The witnesses would disappear or something would happen. And I really thought of him as like a misdemeanor mastermind. But I knew that if he didn't stop, he'd graduate to felonies one day. And he did. So at any rate, the property is found to be in violation. I'll grant... Well, let me ask you this. What needs to be done to abate it?
They need to move out of the sheds.
So
The shed in the garage.
Yeah, but okay, so this isn't about the shed per se.
This case is
it's
not.
about living in the shed.
Living in the shed in the garage.
All right. They're granted 30 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $200 per day will be imposed. This fine will be recorded and will constitute a lien on Mr. Perusik's property. County Attorney's Office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the owner shall be responsible to pay all costs required by county law.
Thank you.
Yep.
Next case on the agenda is Samantha M. Maurice and Jason Pashal. Case number 216-6450. Code Officer Matt Hampton, page 14 of your agenda. Expert on the case, Carl Jones.
The stories I'm telling are for the benefit of our YouTube audience. I understand we have quite the following.
Morning again, Matt Hampton, Citrus County Code Compliance Officer. It's case number 216-6450, construction or modification of a structure without required permits, violation of Chapter 18, Article 1, Section 18.8A of the Citrus County Code of Ordinances. The address is 2784 South Westmoreland Drive, Homosassa, Florida. Property owners are Maurice Samantha M. and Pashal Jason. Good service via signed certified mail return receipt. I just was informed that apparently the permit was pulled this morning. I think Carl may be able to speak better on that.
17th.
Oh, so
Permit was issued on the 17th.
It was actually paid for and issued. All right.
Okay.
Okay, then I guess the county will dismiss it.
Yes.
Or withdraw the case. Okay.
Yes. Withdraw.
Withdraw.
All right,
Withdraw
sure.
the case.
Thanks.
Thank
Sounds
you.
good.
Next case on the agenda, Ricky Wayne Landrum, case number 2170823. Code Officer Amy Becker, page 11 of your agenda.
Amy Becker, Citrus County Code Compliance Officer. This is case number 2170823, accumulation of junk and debris, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 3, Section 20-31A. The address is 9 South Fillmore Street, Beverly Hills, Florida. The property owner is Ricky Wayne Landrum. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on August 10th, 2022. Photos taken on August 31st at my corrective action inspection. And photos taken on my final inspection on October 18th. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, and a copy of the signed certified mail return receipt signed for on September 6th.
Is there anyone from the public who's going to want to be heard on this case? Let the record reflect there's no response. Thank you. Without objection, what's been proposed as Exhibits A and B are evidence.
On August 10th, I conducted my initial inspection for accumulation of junk and debris and observed an appliance and other debris, which is a clear violation of the ordinance listed above. As of my final inspection on October 18th, the property remains in violation. I have had contact with the owner and he's aware of the violation.
Did you have any other cases on this property besides this one?
I had an overgrown lawn, which he mowed, and now it's going to be in violation again soon, as far as the lawn.
So it looked like it was in violation, then it came into compliance. Has he indicated any intention of getting rid of the junk or fixing the violation?
No, he has not.
What has he said?
He said that he's working on it and he wants to make the appliance into something. And he collects stuff.
Okay. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day, along with administrative costs, to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owner once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I adopt the county's proposed findings of fact. The property is in violation. The owner is granted 60 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on the property of Mr. Landrum. I'm giving a slightly longer time to comply just because he did fix the grass issue at first. County Attorney's Office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and Mr. Landrum shall be responsible to pay all costs required by county law.
Thank you.
Next case on the agenda, Charles M. Curry and Victoria K. Cages. Case number 216-4474, Code Officer Jillian Nocella, page 7 of your agenda.
Jillian Nocella, Citrus County Code Compliance Officer. This is case number 216-4474, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 13314 East Shawnee Trail, Inverness, Florida, 34450. Property owner is Charles M. Curry and Victoria K. Cages. Good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Photos taken during an initial inspection on May 11th, 2022. Photos taken at a subsequent inspection on July 26, 2022. Photos taken at the corrective action inspection on September 15th, 2022. And photos from my final inspection on October 18th, 2022. Exhibit B is a copy of the notice of violation and a copy of notice of hearing. Also a copy of the signed certified mail return receipt.
Is there anyone from the public who wishes to be heard on this? Let the record reflect that there is none. Okay, without objection, what's been proposed as exhibits A and B are evidence?
On May 11th, 2022, an initial inspection was conducted of the property. It was observed that there were pallets, chain link fencing, buckets, scrap metal, and other miscellaneous items in the yard and near the shed. On July 26, 2022, I conducted a follow-up inspection and observed scrap wood and metal, miscellaneous items covered with tarps near an RV, and other miscellaneous items stacked near the front door of the home. During the corrective action inspection on September 15th, 2022, those items still remained, and as of my final inspection on October 18th, 2022, the property remains in violation with the items mentioned above still in the yard.
What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with the administrative cost to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I do so find I adopt the county's proposed findings of fact. The property is found in violation. The owners are granted 60 days from today to abate the violation. If the violation is not brought in compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and would constitute a lien on the property of the owners. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the owner shall be responsible to pay all costs required by county law.
Thank you.
Yep.
Next case on the agenda, Barbara Ellen Daniels, case number 216-6442, Code Officer Jillian Nocella, page 8 of your agenda.
Jillian Nocella, Citrus County Code Compliance Officer. Case number is 216-6442, accumulation of junk and debris, violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 5290 East Muzzleloaders Court, Inverness, Florida, 34452. Property owner is Barbara Ellen Daniels. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A is photos taken during an initial inspection on June 15th, 2022, and subsequent inspections on July 21st, 2022, and August 23rd, 2022, and photos of my final inspection on October 18th, 2022. Exhibit B is a copy of the notice of violation and a copy of the notice of hearing, a copy of a continuance letter, and photos of the continuance letter that was posted at the property.
This is exhibits A and B?
Yes.
Okay. Is there anyone from the public who wishes to be heard on this case? We'll let the record reflect that there's no response.
So this was continued.
Without objection, what's been proposed as exhibits A and B are evidence.
On June 15th, 2022, an initial inspection was conducted, and there was observed to be appliances, scrap wood, household garbage, a mattress, and other miscellaneous discarded items all over the yard. During both subsequent inspections on July 21st, 2022 and August 23rd, 2022, the property remained in the same condition. I've spoken with Rhonda Ridley. She's a family member of the property owner, I believe the daughter of the property owner. Spoken with her multiple times, and on October 5th, 2022, she advised me that she had received the certified mail and was aware of this continued hearing date. As of my final inspection on October 18th, 2022, progress has been made. However, the property does still remain in violation. And I have spoken with her again, actually, at that October 18th inspection, and she reiterated again that she's continuing to try to get it cleaned up.
Do you know how much time she thinks she needs?
Yesterday when I spoke with her, she mentioned a couple weeks.
All right, what's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with the administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Property is found in violation, the owner is granted 60 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on the property of the owner. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the day of first recording, and the owner shall be responsible to pay all costs required by county law.
Thank you.
Thanks.
Next case, Audrey M. Maher, case number 2171239, Code Officer Brandon Norman, page 12 of your agenda. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Good morning.
How are you, sir?
Good. How are you?
Good, good. Brandon Norman, Citrus County Code Compliance Officer. This is case number 2171239. Excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20-61 of the Citrus County Code of Ordinances. The address is 5566 South Barco Terrace, Inverness, Florida 34452. The property owner is Audrey Meyer. I have good service signed via certified mail return receipt. Would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during the initial inspection on August 18th, 2022, and corrective action inspection on September 12th, 2022, and photos of my final inspection on October 18th, 2022. Exhibit B, a copy of the notice of violation, and a copy of the notice of hearing, and a copy of the certified mail return receipt indicating good service.
Just a couple of questions.
Yes, sir.
Who are you?
I'm one of the new code enforcement officers.
Have you posted a bond as required to serve as a code compliance officer?
No.
Do you have any proof that you're a code compliance officer?
I gotta.
They don't just give those T-shirts out to anybody.
They give me this too, sir. I don't know.
Okay. All right. I'll accept your representations.
I appreciate that.
Is there anyone from the public who wishes to be heard on this case? Let the record reflect that there is no response. Thank you.
Sir.
Without objection, what's been proposed as Exhibits A and B are evidence.
On August 18th, 2022, an initial inspection was conducted of the property for overgrown lawn. The property was found to be in violation of the above ordinance. The property remained in violation at my notice of violation corrective action inspection on September 12th, 2022, as well as my pre-hearing inspection conducted on October 18th, 2022. I was able to make face-to-face contact with the resident there, who stated the grass would be cut by October 7th, 2022, but that has not happened.
So what did you use to measure the grass?
The initial inspection was conducted. We measured it out on a wooden stake, 18 inches, marked it on the stake.
Okay, I see the
planted it
stake.
in the ground, and then the grass hasn't, obviously.
So the stake's not a ruler, but you know where you measured 18 inches on the stake.
Yes, sir.
With a ruler.
Yes, sir.
Or
With a tape measure.
Tape measure.
Yes, sir.
Okay. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I adopt the county's proposed findings of fact. The property is found in violation. The owner is granted 30 days from today to abate the violation. If the violation is not brought in compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on the property of Ms. Marr. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the owner shall be responsible to pay all costs required by county law. Thank you, sir.
Next case, Sandra J. Mulden, case number 217-0382, Code Officer Alan Jonason, page 13 of your agenda.
Alan Jonason, Citrus County Code Compliance Officer. This is case number, 217-0382, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address of the violation is 1510 North Paulette Terrace, Inverness, Florida. Property owner is Malden Sandra J. I have good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during an initial inspection on 8 August 2022, photos from a compliance inspection on 12 September 2022, and photos of my final inspection conducted on 18 October 2022. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the posting affidavit, and a photo of the notice of hearing posted on the property.
Is there anyone from the public who wishes to be heard? Let the record reflect that there is no response. Without objection, what's been proposed as exhibits A and B are evidence.
On 8 August 2022, I conducted an initial inspection and observed the property to be in violation. On 8 August 2022, a notice of violation was issued for junkyard conditions, which is a violation of the ordinance listed above. On 12 September 2022, I conducted a compliance inspection and observed the property remained in violation. I have had brief contact with the property owner, but as of my final inspection on 18 October 2022, the property remains in violation.
What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with the administrative cost to begin after the date you deem sufficient to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to the violation. We would also ask the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
The property is found in violation. The owner is granted 60 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. The fine will be recorded and constitute a lien on the property of Ms. Malden. County Attorney's Office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the day of first recording, and the owner shall be responsible to pay all costs required by county law.
Thank you.
Next cases on the agenda, Dale and Stephen R. Roberts and Jonathan W. Spell. Case numbers 216-7862 and 216-7863. Code Officer Matt Hampton, signed to the case, pages 17 and 18 of your agenda.
Morning again.
Morning.
Matt Hampton, Citrus County Code Compliance Officers, case number 216-7862, accumulation of junk and debris, violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances, and case number 216-7863, excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20-61 of the Citrus County Code of Ordinances. The address is 5641 South Bhutan Point, Homosassa, Florida. Property owners are Roberts Dale, Roberts Stephen R., and Spell Jonathan W. Good service via posting of the property in Lecanto Government Building. I would like to authenticate the documents and request that they be admitted into evidence. Exhibit A, I have two different sets of exhibits.
Okay.
They'll both have the same thing. just some different pictures.
Gotcha.
Exhibit A, photos I took during my initial inspection, July 11th, 2022. Photos I took for corrective action inspection, September 8th, 2022. And photos I took during my pre-hearing inspection, October 18th, 2022. Exhibit B is a copy of the notice of violation, a copy of the notice of hearing, and a picture of the notice of hearing posted at the property, and a copy of the posting affidavit I completed October 6th, 2022.
Is there anyone from the public who wishes to be heard on either of these cases? Let the record reflect that there is no one. Without objection, exhibits A and B in each case are admitted as evidence.
I conducted my initial inspection on July 11th, 2022 and observed the property to be in violation of both of the ordinances listed above. For the junk case, I observed appliances, furniture, tree debris, auto parts, and other miscellaneous junk and debris around the property. In the lawn case, the grass and weeds exceeded the 18-inch maximum allowed by county ordinance. Corrective action inspection was completed September 8th, 2022. I observed no progress for either violation. I posted the property in the Lecanto Government Building with the notice of hearing on October 6, 2022. I have had no contact with anyone regarding the property. However, I did speak to a neighbor that I had a violation with, and she advised me that all three of these individuals are deceased. I asked her if she knew anybody else, and she said she did not.
So she's not aware of the property even being occupied?
No, sir. As of my pre-hearing inspection, October 18th, 2022, I observed no change to the property.
Do you know how recently the owners became deceased?
I do
or did
not,
she
sir.
mention? Okay.
No, sir. I know it, well, actually, the lady I spoke to, I know it's been some time, probably at least 3 or 4 years. The one gentleman died because he actually died on the front porch, trying to get some help, and nobody was around. She said that was about 3 or 4 years ago. So.
Wow. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the Special Master assess a fine of $50 per day per violation, along with the administrative costs to begin after the date you deem sufficient to abate these violations. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violations and the respondent's actions relative to these violations. We would also have Special Master additionally find it is the respondent's responsibility to contact the Code Compliance Division when the violations have abated in order to allow for inspection.
In each case, the property is found in violation. In each case, the owners, as they may be, are granted 30 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This applies in each case. The fine would be recorded and constitute a lien on the owners of the property. And County Attorney's Office and the county have all the remedies provided for by law and as explained in the speech in the beginning. Thank you.
Final case is a fine appeal. Rodney R. Blake, case number 215-5852. Code Officer J.C. Charlton.
Morning. This is a fine appeal at the property owner's request. Code Officer J.C. Charlton, Citrus County Code Compliance Officer. This is case number 215-5852, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 7488 West Cowhide Path. Property owner Rodney R. Blake. I'd like to authenticate the following documents and request that be admitted into evidence. Exhibit A, photos taken while conducting compliance inspection, follow-up inspections on September 2nd, October 7th, and October 18th, and photos of the posted property. Exhibit B, copies of the finding of fact, affidavit of noncompliance, order of imposing fine, and final appeal letter advising the property owner that his hearing will be scheduled for the day's hearing.
Okay. Is there anyone from the public who wishes to be heard? I see none. Is it exhibits A and B or?
Yes, sir.
Okay. All right. What's been proposed as exhibits A and B are evidence.
A compliance inspection was conducted on September 9th of 2022. I found the property still be in violation of junk and debris. Follow-up inspection conducted on October 7th and final inspection on October 18th. Fixed junk and debris still on the property. Mattress, the garbage remains piled up on the property as well.
How did they request an appeal?
He came into the office.
Mr.
and-
Blake came into the office?
Yes, sir.
Okay. I mean, did he say anything when he?
I didn't speak to him.
Yeah.
Lori spoke.
I spoke to him.
Okay. Can you
Well, he
swear
said-
say in? Can you?
Yeah, do I swear to tell? I
Do you
swear
do you
to tell
swear
the
do you
truth.
swear an oath to tell the whole the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay.
He just stated that there were tenants there, they finally got them out, and he thought the fine was too high.
Okay. Appeal denied.
Thank you.
Is there anything else left on the agenda?
No, sir.
Okay. The time is 11:04, and this hearing is adjourned.